Daniel. Okay, there we go. Welcome to RainierAvenueRadio.world and our community election connection. This is the debate for Supreme Court Justice position number 6. Candidates are incumbent Justice G. Helen Whitener. Let me make sure I said that right. Is it Whitener or Whitner? Justice?
It's Whitener.
I'm sorry?
Whitener.
Whitener, thank you. And candidate Richard S. Serns. And I'm going to share some information on the rules and on our candidates and our moderators, and then we will be getting started. Each candidate will get a 2-minute opening statement and a closing statement. Each candidate will be allotted 2 minutes to respond to the questions that our moderators have, and then a 30-second rebuttal. We're going to rotate between our two monitors, and time permitting, each candidate will also be able to ask their opponent a concise question. The asked candidate will be given 1 minute to respond, and the candidate that asked the question will be given 30 seconds to ask a follow-up question. The candidate that is asked will be given 30 seconds for rebuttal. And as we get started here, I'm going to introduce our candidates, and then I'm going to introduce also our moderators. And I'll give you some background information that you can find. I'll put this up for you. Right here. This is where you can find everything, your voter's pamphlet. We're going to continue to provide you with information. We'll be airing a various number of debates and interviews with candidates throughout the month of August, and that is our Community Election Connection. I'd like to thank our sponsors, the Urban League of Metropolitan Seattle, and SAS, Seattle Academy of Arts and Sciences, our sponsors for our Community Election Connection. And I'm going to start with Richard Serns. And again, you can find this information. Dr. Serns' statement says that his election to the Supreme Court will provide invaluable expertise in the important field of education law. After teaching Washington State history and government, Dr. Serns worked as a K-12 principal and completed his PhD researching education law in Washington State. After completing his law degree from the University of Washington, he continued working with Washington school districts as Director of Employee Relations, Assistant Superintendent, and Superintendent. And also, G. Helen Whitener, Justice G. Helen Whitener. The statement says, I have over 21 years of legal experience, and I'm asking for your vote and continued support. Legal experience matters for this position, and I am the most experienced candidate in this race. I presided over thousands of cases to include complex criminal, civil, and family law jury trials. I have a reputation for efficiency, fairness, and making well-reasoned decisions in resolving complex legal disputes across a broad range of subject matters. I lecture to members of the legal and non-legal community, locally, nationally, and internationally. I'm a faculty member of the Washington Court's Judicial College, where I teach newly elected or appointed judicial officials. I also teach a street law civics class to high school seniors at Lincoln High School in Tacoma. There will be a clock that you will see that will count down the necessary time. I'm now going to introduce our moderators to you. And I'll start with Monique. Monique, how are you?
I'm well. How are you? Thank you for having me.
And our first moderator, you can catch her on Thursdays, does a show Afternoons with Monique at 1 o'clock. Monique Lee has lived in Washington State for over 30 years, a graduate of the UW Business School and contributing columnist to 2 local community newspapers for 14 years. She is the host of Afternoons with Monique. Upon graduating from the UW's business school, Monique became a wealth manager for a reputable international investment brokerage. Currently, she is the founder of Seattle Love Broker, a relationship consulting firm. Monique is a former member of the National Women's Political Caucus, a state-certified translator, and the Mensa International member. Welcome, Monique.
Thank you for having me.
And also, our other moderator is Mr. Paul Scheiderman. Paul also has a show on Rainier Avenue Radio, Sports and Stuff, where he does amazing interviews with incredible people. Paul has a Bachelor of Arts degree from the University of Washington, and he is a graduate of Seattle University School of Law. Paul works as a solo attorney at law offices of Paul Scheiderman in Seattle, a firm that focuses on primarily personal injury cases and civil litigation. Paul, again, is the host of Sports and Stuff, which you can catch every Monday at 8 o'clock right here on RainierAvenueRadio.world. Okay, I flipped a coin earlier, and producer Daniel Bellis watched me flip it. Since we're doing this virtually, we're still going to have this coin toss about who goes first with the questions. So, Justice Whitener, I've written it down on this piece of paper, and so if you will just call heads or tails, I am going to let you know whether it's what the coin flip was. So, Judge Whitener, or Justice Whitener, would you please call heads or tails?
Heads.
You said heads?
Heads. Can you hear me?
Can we get more volume on that, Daniel, please? Okay, let's try this again. Heads or tails?
Heads.
Okay. It's tails. So, Mr. Serns, you have the option of taking the first question, or you can defer, and Justice Whitener will take the first question.
I ask you a clarifying question. Were we going to have a 2-minute introduction from us, or was that what you did already? We're going right into
no. You're gonna get a 2-minute introduction. I'm just getting all of the preliminary stuff out of the way. So once we get rolling, we'll be rolling.
Okay. I'd be happy to take the first question.
Okay, and with that being said, I'm going to go ahead and give you the opportunity to do your introduction, and then I'm going to turn it over to the host. Thank you for listening to RainierAvenueRadio.world, our community election connection, and this debate for Supreme Court Justice position number 6. Mr. Serns, go ahead. 2 minutes.
All right. First of all, thank you for having us. And 2 minutes isn't much time, but I'd try to be fairly concise here with what I want to say initially, and perhaps we'll come back to some of these points later on in the interview. I think a lot depends. A lot of the discussion is going to surround my experience versus Justice Whitener's experience. I've said from the beginning that I treat running for public office and running for this particular position like applying for a job. I didn't choose to run for this election because I thought Justice Whitener was not qualified or that she won't do a good job. I think if she continues, she'll do an excellent job, and she has a very impressive resume. I think the response to my qualifications and credentials has been mixed. I've had people very encouraged and refreshed that there's a new outside perspective that might possibly be available to them. And there's others who think it's extremely audacious that I should apply for this position with the limited experience I have in the actual practice of law, which is zero. My career has been in education, as you've mentioned, and I went up from being a teacher to a principal and then eventually a superintendent. I worked most of the time, over 12 years, in human resources, and that's where I got the most experience that would be applicable to law. And I've also taught school law at Seattle Pacific University. Within the field of education, there's so much regulation and law that one has to be very aware of due process, freedom of speech, freedom of expression, labor and employment law, special ed law, all sorts of different areas that I've been responsible for, and I've written policies for 2 school districts reviewed and rewritten their entire policies of over 400 policies and procedures, because my PhD was in policy development and analysis before I got the law degree. I can, just as a clarifying comment, I don't see the time, so I'm not sure how I'm coming. Was there supposed to be a clock that we can look at?
Window that you should be able to see. What is the time now, Daniel? Well, we've got 5 seconds left, so I'll give you about 10 more seconds.
No, I'm fine. That's enough for now. Can you hear me okay?
Yes.
Yes.
Okay, thank you.
Okay. And Justice Whitener, 2 minutes for your opening statement.
Thank you. Good afternoon for having me on your panel. I do appreciate it. I am Washington State's first Black female Supreme Court Justice. But I'm not there because of the color of my skin. I'm there because of the content of my character, as well as my qualifications. Prior to joining the Supreme Court, I was a Superior Court judge for 5 years. Prior to that, I was a Board of Industrial Insurance Appeals judge. I've been a prosecutor, I've been a public defender, I've been a private defense counsel, and I've also been a pro tem judge on the district court as well as the municipal court level. I have written opinions since joining the Supreme Court. I have 2 written opinions. There were 9 all majority opinions that have now been published. One of my opinions is circulating. I have sat on oral arguments since being at the Supreme Court. And we're presently in session listening to oral arguments as well. And as you've heard, I have thousands of cases that I've sat on, to include complex civil, criminal, and family law matters. What's important, I think, as well, and what's unique in regards to my experience, is I've been in all 3 roles on all 3 levels of the trial level court. So I've been a prosecutor, a defense attorney, and a judicial officer in the municipal district court, as well as the Superior Court. And I've written opinions as a Board of Industrial Insurance Appeals judge, and now since sitting on the High Court. I also co-chair the Washington State Minority and Justice Commission, which deals with race and equity issues in our courts. I am a Supreme Court judicial appointed judicial officer to the Office of Civil Legal Aid Oversight Committee. And that committee deals with financial issues in regards to access to our courts as well. 2 things that are near and dear to my heart. I look forward to answering any questions you may have. Thank you.
All right. I am going to now turn it over to our moderators. And Monique, we will start with you if you would like to address your first question to candidate Serns.
Dr. Serns, welcome to the show. I have a question that I'd like to ask you. Actually, I would like to ask both Justice Whitener and Dr. Serns this question. In order to understand your predisposition or background or what is in your head, I'd like to find out who is your most admired or favorite Supreme Court justice, U.S. or Washington State Supreme Court. Dr. Serns?
We've been asked that question before. It's a good one. I've answered that the one that I've appreciated most as I've studied various holdings and writings is Justice Brennan of the U.S. Supreme Court. He's no longer there, but he was, I think, the thing I admired about him was his insight and his ability to see all sides of a situation. When you'd read a case, a holding, it would be very compelling. Then you'd read the other side and be very compelling. And then he'd come along and point out things that neither one of them had thought of before. And I think that's one of the most important things in the role of an appellate justice, is that you have something to contribute to the whole. It's not like a trial judge where you're just the only person making the decision, but you're a panel and you deliberate and you bounce ideas off each other, you research together, you listen to one another. And while I haven't served in that capacity, that's the type of work that I have done. And I think the role that I've often played in problem solving is to try to think, use the cliche outside the box, but think in ways that people haven't thought about an issue before.
Since that appellate judge is a little bit less prominent and less identifiable to voters, if I may ask a follow-up question, who in the current U.S. Supreme Court do you look at as someone that you follow in terms of ideology? And I probably will ask the same of Justice Whitener.
You'll have 30 seconds for this answer, Dr.
Okay, a
Serns.
very strong part of my my whole campaign and my philosophy is that I'm clearly don't identify myself as a Republican or a Democrat, even when I'm not running for a judicial position. And I don't think I fit neatly in a box of conservative or liberal. So I want to say that in advance. But I think of the current justices, I have learned to respect Justice Roberts, who tends to have a conservative reputation, but I think is very fair-minded and will listen to both sides.
Same question, Justice Whitener.
Thank you. I don't have one. I have three that I identify with, and two actually are now passed.
I think we got to go back to the initial question. Monique, would you want to repeat that initial question to Justice Whitener as well?
Sure. My question was, who, dead or alive, U.S. or Washington State or anywhere, is your favorite, most admired Supreme Court justice? That's my original question.
Okay. So thank you. I still don't have one. I have three. And two of them are deceased. One is Justice Thurgood Marshall, because of his role in regards to equal rights and his advocacy. And before joining the bench, I see him as a role model because of my advocacy, having done both sides before getting to this level. I also liked fairly recently passed Justice Ruth Bader Ginsburg. She stood up for women's rights, and I thought her decisions were very informative. And what I think is relevant to my position now is her dissents. She has taught me that I can make a decision and have a strong legacy with that decision if I don't agree with my case by writing a very strong dissent. So I like her and her writings in regards to that. And thirdly, I love and I like Justice Sonia Sotomayor because she has kept it real. She is very authentic in regards to her heritage, and she brings that to her writing. And her view is, and her lens in regards to her decision are blended through her culture and who she is. She's very much well-grounded. Being an immigrant, I really like that perspective. This is Sonia Sotomayor.
Thank you, Justice Whitener and Dr. Serns.
Do you have a follow-up, Monique, for Justice Whitener?
No, I understand her position. I hope that is enlightening to our listener. I'd like to pass the baton to Paul to ask the next question.
Okay, Paul, and will you direct your first question as well to candidate Serns?
I will. Thank you, Tony. Thank you, Justice Whitener, for participating, and Dr. Serns. I have my question. I'd like Justice Whitener to opine on this as well. Is, as we know, many U.S. Supreme Court justices and legal academics espouse a philosophy of how to interpret laws. Do you have a general philosophy of how to interpret statutes and other legal issues that will come in front of the Washington State Supreme Court?
And again, the initial question goes to you, candidate Serns.
Okay. Well, the two poles are typically a strict constructionist and viewing the Constitution as a living document. In most areas of my life, whether it's the law or whether it's political persuasion, religion, whatever it is, I tend to sometimes play the devil's advocate, but sometimes usually end up somewhere in between. My judicial philosophy, I think, would be the same. I think first and foremost, justices need to look at the plain meaning of the law and the intent of the law the best they can ascertain that. And justices are not to be legislators. However, having said that, I don't think it's improper for the court to understand that they may have a responsibility of contributing to an evolving understanding of different terminology and so forth. The example I often use is when our founding fathers talked about all men being created equal, only male white landowners could even vote after they said that. So the concept of equality certainly has evolved immensely and needs to continue to evolve. I think the court sometimes has a role in that evolution, but it primarily should be the legislature, and the court should not be making laws, but interpreting them.
And any follow-up? Monique?
I don't. If possible, it'd be interesting to hear Justice Whitener's perspective on that question, too.
Okay.
Can you repeat the question, please?
Yes, my question, Justice, is many academics and Supreme Court justices have espoused philosophies of how to interpret laws. Do you have a general philosophy of how to interpret statutes and other legal issues that come in front of the Washington State Supreme Court?
Well, I just got there, but I would have to rely on my experience before getting there. And I don't necessarily have a philosophy. I don't bind myself by any particular philosophy per se. I make my rulings based on the law. So it's a rule of law that basically guides any decision that I make. And then you apply the facts. And the facts vary from one case to the next. So my decision and my philosophy in regards to my decision will always be based on the rules that I have to apply and the facts that I have to interpret those rules with. Now, having said that, I think what you're trying to get at is whether or not I am willing to make rules or make law. And there are times and circumstances where the Supreme Court makes law. And it is during those times where we set precedent for the lower courts to follow. I think your lens that you bring to the discussion, and my lens is very marginalized. I'm a Black woman, I'm an immigrant, I identify with a disability, I'm LGBT. My lens will always influence how I view the law and how I view the facts that come before me. I think that is for everyone that has a case where they have to apply the facts and the law. But I wouldn't say I necessarily have a philosophy, since now getting to the highest court, I would think my philosophy would be one that is evolving and growing as I do this job more and more.
And Mr. Scheiderman, any follow-up?
I don't. Thank you, Tony.
Okay, and we'll go back. And Monique, will you direct your next question initially to Justice Whitener?
I'm sorry, what were you asking? I thought Dr. Serns was going to address the same question from Paul.
That's right.
Went first.
Thank you. All right. Candidate Serns, same question.
No, I think I went first on his question. I already answered it.
That's right. That's what I thought. Okay. So, Monique, your next question will be directed towards Justice Whitener.
Okay, so I have a question specifically for Justice Whitener and one specifically for Dr. Serns. Diversity is important in the court. Current Washington Supreme Court is the most diverse, I'm told by the legal community, my lawyer friends, that the current Washington Supreme Court is the most diverse Supreme Court in the country, if not ever. So my question to Justice Whitener is it really a good idea to have such divergent point of view? And does that diversity, or possibly I call it divergent or diversity, depending on where you're looking at it, is that would that create a lack of consensus among a collegial court? In other words, does diversity cause discord and destabilize the law and eventually society? What do you think about that, Justice Whitener?
Absolutely not. First of all, diversity does not mean diversity of thought. You have a number of different types of diversity. I gave you some of the labels used to identify me and diversify me as far as a person. In regards to profession, I also have a very diverse professional background. What that does is it brings that lens to the discussion and helps it be more informed because our community and our society is multicultural and multi-ethnic and multi-professional. That's what it does. That's what diversity does. It brings depth to the discussion and it brings different lens to bear on the issue that is being heard. And if there is experience in the law, as far as practical experience, that comes to bear on the issue as well, which is why I believe that legal practical experience matters, where I have the practical experience of having been a lawyer, a practicing lawyer, having been a judicial officer, and now sitting on the high court. That matters in regards to how the law is viewed, how it is interpreted, because I understand the application aspect of the law, where my opponent here does not. He has theories, and he has exercised those theories in certain circumstances, but he has not practiced law, because if he had, he would have been committing a crime. You have to have certain competencies to pass the bar, that is one thing, and then get experience, be bar certified, and then get experience. My opponent passed the bar this past, he was sworn in as an attorney this past April. He got bar certified this past May, and he, as he has admitted in his opening statement, he has never practiced law. There's a reason. Practical experience matters.
Okay. And Monique, your question for candidate Serns.
Actually, Justice Whitener kind of touched on what I was going to ask Dr. Serns. The question has to do with his qualifications. And I read on Dr. Serns' website as well as Ballotpedia the vast variety of experiences. And Dr. Serns, you're very educated. You have a PhD from 1992 and a JD from 1999. And so you've had a lot of education as well as theories, and you also apply a lot of that knowledge in various capacity as an educator, an HR administrator, but you don't have any practical application of the judicial process, as Justice Whitener just mentioned. So how do you think you are going to apply the law and also form consensus with the fellow justices on the current bench if you don't have an overall understanding of how all of these theories apply to the court of law in Washington state? And I'll have a follow-up question. I'll have you address that. How do you see your role fitting in if you don't have any practical experience in the judicial sense?
I'll try to keep this to 2 minutes. I'd like to quickly respond to your question to Justice Whitener. I highly value diversity. I think she spoke exactly correctly. Diversity in characteristics of people is entirely different than diversity of thought. I think we should be proud of the fact that we have such a diverse Supreme Court, but we don't necessarily have diversity of thought. We have 5 of the current 9 justices have been appointed and have had the opportunity to run as an incumbent then before they were ever elected. I would have preferred running for an open seat and not running against Justice Whitener because I respect the diversity of personality and so forth. But to go back to your question, as far as it goes back to the experience question, I think there is a particular value in having unconventional experience sometimes. I think it can give people the ability to have insights that's actually a strength to an organization. They have insights that because they're coming from a different perspective. Certainly there's a learning curve whenever you do something different. An example I want to refer to, the people of Seattle will know well, and particularly those who have been around for a while. In 1995, John Stanford was selected as a superintendent of schools for Seattle Public Schools. He'd never been a teacher, never been a school administrator, but he did an outstanding job. He was a retired Army general, and trust me, I'm not trying to compare my accomplishments to John Stanford. He's an icon. But my point is that unconventional preparation sometimes gives you as good or better preparation to have insight that's different from those who have
And
had
that's
the
time.
experience.
That's time. Thank you.
Thank you.
And Mr. Scheiderman, would you like to direct your question initially to candidate Justice Whitener?
Sure, and I'd also like Dr. Serns to please comment on this question as well. My question is about ideology in the judiciary. Right now in Washington, D.C., there is a Supreme Court nominee who's espoused definitely some politically conservative thinking like on the right-leaning side. We also had a King County Superior Court judge last year who said that she's an example of how the resistance looks in a black robe. Whether it's right or left wing, do you think the judiciary has become too political and ideological, and this is doing damage to the judiciary?
I think judicial officers need to understand their role and comply with their canons. I don't believe advocating from the bench is appropriate. I believe that runs afoul of our canons. Having said that, I don't believe you lose who you are in interpreting law, in applying the law, and in trying to empathize with others. I think diversity of thought, diversity of background, and diversity of experiences matter in that regard. I don't think you should be doing certain things from the bench. You have to comply with your canons. And for me, it's the rule of the law. And that's my role. When you put on that robe, you've taken an oath. It's about applying the law to the best of your abilities and not trying to legislate from the bench. That's a no-no as far as I'm concerned. In regards to political ideologies, that's not our role. We're supposed to be nonpartisan. And I think being so marginalized and having judicial experience behind me where I've been tested indicates that I know how to disassociate my decisions from any aspect of me in making the best decision in applying the law. The law is not a place to pontificate about political issues unless it's relevant to the case that's before you.
And candidate Serns, same question. Would you like Mr. Scheiderman to repeat the question, or?
Yes, please.
Yeah, my question to Justice Whitener and also to you, Dr. Serns, is there's a lot of controversy from some people who are seeking judicial positions or in judicial positions who've made some comments and espoused some, whether liberal ideology or conservative ideology. Do you believe that whether it's on the right or left, do you believe the judiciary has become too political and ideological, and this is doing some damage to the judiciary?
I absolutely feel that, and that's one of the pillars of my campaign and why I'm running. I have not identified myself as Republican or Democrat for a long time, and I don't think I fit neatly into a box of a label of conservative or liberal. So I'm not stating this because I'm coming from any of those perspectives. Sometimes I probably reflect all four of those. Sometimes I reflect none of them. But I think, I personally think that I would love to see all political offices in the legislative branch and executive branch be nonpartisan. I'm appalled at the polarization of our government at this point, where it's a winner-take-all and zero-sum game. And I think it's unfortunate because of the importance of checks and balances when the executive branch and the legislative branch are even from the same party. But what we're coming to now is sometimes the judicial branch is co-opted into that as well. Well, I respect all of the current justices in the Supreme Court, and I think they would all tell you that they are independent. The fact that 5 of them have been appointed by a Democratic governor out of 9, I think is an end run around the ability of people to select candidates and elect them like our Constitution expects without them having the advantage of running as incumbent before they've ever faced election.
Mr. Scheiderman, any follow-up?
Sure. Is it your position, Dr. Serns, that the current Washington State Supreme Court is too ideological in one particular direction?
30 seconds.
I'm not familiar enough with all of their rulings to say definitively that that's what I believe, but that's certainly the perception. And I don't know definitively how often there's dissent, but I'm pleased to see that Justice Whitener said she's certainly willing to dissent. I think dissent is valuable. You should never make dissent just for the case of being different, but if everybody always agrees, there's a problem.
You are listening to RainierAvenueRadio.world, our community election connection. This is the debate for Supreme Court Justice position number 6. The candidates are incumbent Justice G. Helen Whitener and candidate Dr. Richard S. Serns. We're going to take a short break for about 2 minutes. When we come back, the initial question will be asked by Monique, and that question will be for you, candidate Serns. We'll be back in about 2 minutes.
RainierAvenueRadio.world, breaking radio boundaries.
I'ma keep on running cause the winner don't quit on themselves.
This is the news on Rainier Avenue Radio.
Officials with the Washington State Department of Health reported 24 more confirmed cases of the coronavirus earlier today. Per Patch.com, the number of deaths was actually inflated by 2 issues with the state's data. Firstly, the state no longer updates the number of coronavirus-related deaths over the weekend. Then, issues with the data processing Monday caused the state to pause death reports for an additional day. In total, that means that Tuesday's report of 24 new deaths includes deaths that happened anywhere between Friday and Monday evening, an average of 6 deaths per day. During that period, deaths were reported in Atherton, Benton, Chelan, Clark, Grays Harbor, Lewis, Mason, Pierce, Snohomish, Spokane, Thurston, Whatcom, and Yakima counties. Tuesday's report also included 404 new confirmed cases of the coronavirus, bringing the running total to 87,042 COVID-19 cases in Washington state since the pandemic began.
And that's your news on Rainier Avenue Radio.
The Urban League of Metropolitan Seattle, empowering communities and changing lives. The Urban League has been there to serve when our community is at its lowest. It's never mattered what the crisis was. The systemic oppression remains constant for those most vulnerable. Here at the Urban League of Metropolitan Seattle, we'll be temporarily adjusting our hours of operation and available services. If you are in need of resources, we recommend that you give us a call at 206-461-3792. To make an appointment, press 0 and speak with the receptionist. Walk-in hours will be from 10 a.m. to 3 p.m. Monday through Friday. And hey, we'll gladly work with you via phone as best as we can if you're exhibiting any signs of illness to assist you with information to save your home, find you a place to sleep, or connect you to job opportunities. The Urban League of Metropolitan Seattle. That's 206-461-3792.
You're listening to RainierAvenueRadio.world. Check us out on social media. Facebook and Instagram, RainierAvenueRadio.world, and on Twitter at RainierAvRadio.
Welcome back to RainierAvenueRadio.world, our community election connection. This is the debate for Supreme Court Justice Position 6. Candidates are incumbent Justice G. Helen Whitener and candidate Dr. Richard Serns. Our moderators, Monique Lee, you remember her from Afternoons with Monique, and then also Paul Scheiderman from Sports and Stuff right here on Rainier Avenue Radio. Quickly, a judge or a judicial candidate shall not make any statement for the purposes of this debate that would reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court or in connection with cases, controversies, or issues that are likely to come before the court. Make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of judicial office. Welcome back, and I will turn it over to you now, Monique, and the first question again will be for candidate Serns.
Okay, so Dr. Serns, in September of 2010, a debate between then and candidate Wiggins, now Justice Wiggins, and then Justice Richard Sanders, now retired Justice Sanders. Then candidate Wiggins said, "The election is a humbling process. You basically go and lay bare your soul, and you submit yourself to questions, talk to folks, It forces a candidate to confront issues that you may not have had to confront before. What issues have you been confronted with during the election? And what have you learned from this process? Dr. Serns first, and I'd like to ask the same question of Justice Whitener.
2 minutes.
I agree with the statement. It's a very humbling experience. It's a very good experience for both candidates and the public, I believe. I think that everyone grows from discussing the different options. One of the issues that's been on my mind that's probably most difficult for me to address is, as I mentioned, I've been a champion of diversity throughout my career. And in that respect, I felt somewhat uncomfortable running against Justice Whitener. As I mentioned, I would much prefer to have run it for an open seat, but we've had 2 open seats in the Washington Supreme Court races in the last 28 years because of appointments by governors. So it's almost impossible to run for an open seat. But that has caused me to really think through and analyze why I'm running. And as I've stated before, it's important for me that there's diversity of thought as well as other types of diversity, and that our courts are respected for being nonpartisan. That I do respect Justice Whitener, and I think we agree with each other on many key issues.
And any follow-up, Monique?
What have you learned? Well, you kind of touched on it, but I'll ask if you would like to articulate any more what you've learned from the process of running against an incumbent such as Justice Whitener.
30 seconds.
Well, it's humbling to hear Justice Whitener's experience. I think I've been misunderstood as feeling that experience is not important. I think experience is extremely important, and her experience is very impressive. My case is that I just think there's sometimes alternative experiences, like I mentioned earlier, that can also give you the skill set. Wouldn't think it would be even more audacious for somebody to be 25 years old and running for this position, but I have had a lot of experiences that I think contribute to the skill set.
And time. And Justice Whitener, same question. Would you like Monique to repeat the question?
Yes, please.
So in September of 2010, there's a debate between now Justice Wiggins and retired Justice Sanders. Justice Wiggins said during his running for the Supreme Court seat at the time, the election is a humbling process. You basically go and lay bare your soul, and you submit yourself to questions, talk to folks, and it forces a candidate to confront issues that you may not have had to confront before. What issues have you been confronted with during this election, and what have you learned from this process?
Well, as far as issues have been confronted with, most of it was brought about by COVID, and that is I was appointed, or at least announced, by Governor Inslee on April 17th. And by the way, that's the same day I believe my opponent was being sworn in as an attorney. I started the job by leaving Pierce County Superior Court on April 23rd, and then, of course, got sworn in as a Supreme Court justice on April 24th, during COVID, by the way, and then had 1 week to get up to speed for oral arguments. So the challenge for me was trying to navigate this big move from Superior Court to the High Court during this pandemic with such a short time frame, having never, of course, done appellate work like this. I was a Board of Industrial Insurance Appeals judge, so I've written opinions, and then find myself 1 month later, or actually a few weeks later, in a campaign. So what has been difficult is maneuvering from my past position to this position, getting up to speed, which of course my experience came to play. And then of course, trying to figure out how do I campaign in a virtual world. So my campaigning my entire life since COVID hit has been in this platform. What I've learned is I had to meet and be vetted by the legal community. So I've been vetted and found exceptionally well qualified by 13 bar associations, but all in a virtual world. So whereas I would have had to travel to meet them, this platform actually made it a little better, but it's very challenging in that there's so many Zoom things that can be fit into a day that it's very exhausting. So that was challenging for me. And then, of course, finding myself in a race with an opponent who's never practiced law
And
is challenging.
that's
in and of
time.
itself.
Thank you.
Thank you.
And Mr. Scheiderman, 1 minute, your first question should be directed towards candidate Serns, and each candidate now is going to get 1 minute. I'm going to try and get more questions in here, so you're going to get 1 minute to respond. And so, Paul, your question should be directed first to Dr. Serns.
Thank you. This was a question that Monique and I discussed a little bit before this forum. The Washington State Bar Association has come under scrutiny in recent years in concern of some financial and personnel matters, as well as some decisions surrounding admittance and discipline. The Washington State Supreme Court basically right now has the last word on WSBA matters, including disciplinary and admission issues. Is this the best system? And are there any reforms you would support in how the WSBA is run and managed?
60 seconds.
I think it's an excellent question. I have somewhat mixed feelings on it. I think it's worked quite well for the Washington State Supreme Court to have oversight of the Washington Bar Association, and I can see why there's a rationale for this. However, I can also see an argument for a professional organization being independent of governmental oversight. So I know that's not a particularly clear answer, but I guess I'm a little, I'll have to think about that a little bit more to know which side I come down on.
Justice Whitener, where are you on some of these WSBA issues?
Well, I think you should know I can't answer that question because the Supreme Court is the one that makes the final decision in regards to disciplinary matters, in regards to the Washington State Bar Association matters. And these are current issues that are being dealt by the High Court. So I'm unable to answer that question.
Are there any reforms you'd support of the WSBA outside of any decisions you may be making as a justice?
Well, the interesting thing is, remember, I just joined the Washington State Supreme Court, so I'm still very much in the mindset of a member of the WSBA per se, and not one that makes the decision. So I think my thought process is still forming in regards to where I stand on that right now.
Okay. And our next question will be Monique, and please direct this question to Justice Whitener, and there will be a 1 minute response.
Thank you, Justice Whitener. That was illuminating of, you forming the thoughts on the WSBA. My question has to do with the affordability and access to justice. The average person doesn't have any idea how the judiciary system works. They don't read your opinions, concurring or dissenting. Why should they vote for this position? And also, how would they get informed in their decision making who to vote for in the Supreme Court races? Justice Whitener.
60 seconds.
A number of things. First of all, yes, they may not write or read the court's decision, but my approach since joining the judiciary hasn't changed since I got to the Supreme Court. I'm very active in the community. I do a lot of educating in the community in regards to the law. I also have worked over the years of bringing the community into our court so they can see the court at work, because the court impacts, especially the trial level courts, impact all facets of our lives, more so than the higher courts, really. So that's where the true impact the court can have on a person's life is seen. In regards to bringing them into the court and educating them, it's educating them on how the court works, what the court can do for them. Unfortunately, we tend to see individuals come before the court involuntarily after they've gotten into trouble. So I have made an effort of going out into the community. I have many things that I do out in the community to teach, as well as Lincoln high school students. And then I have also put on programs in the court where I bring the community in to have them see their court at work. We work for them. So therefore, we need to interact with them, and not only when we're ordering different things that affect their lives.
And Dr. Serns, same question. Would you like the question repeated?
No, I think I have it. I think that the lack of understanding of issues is an extreme problem in all of voting, not just for judicial branch, but for legislative and executive branch. So I think there needs to be a great deal of effort on all of our parts to do a better job of educating. I'd like to give kudos to Justice Whitener, for her street law course that she teaches, and that's something I'd like to become involved in too. I think helping young people understand the importance of civics and how to vote on different issues while they're still in school before they even become adults is probably the best place to start. But we just need to look for ways of constantly educating people. It's a huge challenge.
Okay, and I'm going to move along here. Mr. Scheiderman, you will be asking the next question, and would you direct that question to Dr. Serns, candidate Serns, initially?
I will. Doctor, I know you've been an attorney for a relatively short time, but is there any case or issue that you've worked on where you made a mistake, and what was the mistake, and how did you address the mistake?
That's a good question. When we've been in these types of discussions in the past, we've had a similar question about what keeps you up at night. We all make mistakes. I'm not trying to be evasive. I can't think of one right offhand where I've been troubled by a huge mistake, but we have answered the other question. Anytime you make a decision that affects somebody's life, whether it's employment or incarceration or whatever, you have a tremendous weight on you. And the only time that I would feel, I've never questioned my commitment to justice and fairness. The only thing that I think I might question is, have I always gotten enough information to make the best possible decision? I think we need to make sure that we give every person absolute ample opportunity to state their case.
And Justice Whitener, same question. Do you need the question repeated?
No, I don't think so. I thought the question went to practicing law, and I don't know that Dr. Serns practiced law, so I don't think he answered your question. But in regards to any case that I have handled, well, all cases have bothered me. I can't really think of one particular case that has, where I made it, I've had a few cases where I've made what I believe, after giving it some thought, the wrong decision. And therefore, when I came back out on the bench, I corrected myself and I indicated to counsels why. Now, the last 3 years I was at Pierce County Superior Court, I was on a civil trial rotation, which meant it's very heavy, as you know, motion driven. So sometimes you're making decisions very fast and you're applying the law the best way that you can. And I found myself sometimes afterwards thinking about it and saying, no, I think I got that wrong. And I'm not afraid to come out and tell counsels, I've given some thought to this and I'm going to change my position, and here is why. So that has occurred throughout my judicial career. And I don't think it's a bad thing. It means that you can't continuously trying to apply the law to the best way you can to the facts.
And that's time. What an outstanding job. We're almost out of time here. Thank you so much to our moderators, Monique Lee from Afternoons with Monique and Paul Scheiderman. You can at Sports and Stuff. You can catch them both. Right now, we're going to go to final comments. And Dr. Serns, you won the toss. So would you like to go first or second as we get to closing comments?
I'm fine switching places and letting Justice Whitener start.
Okay, Justice Whitener, 2 minutes for your closing comments, and thank you so much for joining us.
And thank you for having me, and thank you, Dr. Serns, again. I'm Washington State Supreme Court Justice G. Helen Whitener. I've had the position since April. You've heard a lot of discussion about being appointed. You can be appointed to a job, and if you don't know how to do the job, or if you don't have the experience for the job, that's where the voters come in. I've been tried, and I've been true. I've been vetted by the community. I've been vetted by legal bar associations, 13 of them, and they have different ratings from no qualifications to exceptionally well qualified, and I was rated exceptionally well qualified. I have the endorsement of judges, justices, judges, as well as on all levels of our courts. I have earned my badge by working my way through our courts as a prosecutor, public defender, private defense counsel on all the trial level courts. I understand those courts intimately. Those courts' decisions affect your lives. And then you have the opportunity to appeal those decisions to the higher courts, Court of Appeals, and then it can come to the Supreme Court directly as well. Having someone like me with not just a diverse background, but a diverse experience, professional background is integral because I can understand the man on the street, I can understand the issues facing our trial courts, and I can then voice my opinion at the table with my colleagues, bringing that perspective to the decision that has to be made. I'm experienced, and I'm asking for your vote November 3rd. Thank you.
And Dr. Serns, candidate Serns, thank you again for joining us as well. And you as well have 2 minutes for your closing statement.
Thank you again for this opportunity. We've talked a lot about experience, and I've said before that I think experience is important. I just wish to make the case again that unconventional experience can sometimes give you the same skill set and may give you insights that are valuable to an organization. I've used the illustration before. The reason experience does not definitively decide how a person thinks, it's not like learning to fly an airplane or do brain surgery or something, that people with years and years of experience have divergent views on the law. I've used the example, for example, of Justice Scalia and Justice Ginsburg were poles apart, but they had this equivalent number of years of experience. In the political world, President Reagan and President Obama had equivalent years of experience, but they didn't come to the same conclusions about issues. So experience is invaluable, but unconventional experience can sometimes give you insight. And I do have a concern that the judicial system, and I'm not speaking just of Washington, but Washington State, federal, and throughout the nation, has been somewhat co-opted by the political divide that we are in right now. And I think we need to address that. And again, I want to say, like I did before, I respect Justice Whitener's experience. I think she will do a fine job if she's retained. I think I will also do a fine job if I'm elected. And I think the voters just need to decide what skill set and experiences that they prefer. My experience in HR, I might just close with, many times we've come out of interviews with candidates for a position and we say, I wish I could hire both of them, or I wish I could hire all three. So the voters are the selection committee, and they just need to decide what they value. But thank you.
All right. Thank you again to our guests for this debate, candidate Dr. Richard S. Serns and candidate Justice G. Helen Whitener. And thanks to our incredible moderators, Monique and Paul. Great job, y'all. Monique, you can catch her on Afternoons with Monique every Thursday at 1. And Paul Scheiderman, sports and stuff at 8 o'clock on Mondays. We've got the news up next. I'd like to say again, special thanks to our sponsors, Urban League of Metropolitan, Seattle, and also Seattle Academy of Arts and Sciences. This has been your debate for Supreme Court Justice Position 6. We will be airing this again. That's it. That's all the time that we have. We'll be back for our next interview on Community Election Connection, which will be a conversation with Whitney Keys, Executive Director of the Washington State Debate Association and Seattle City Club. We're going to talk about debates at 5 o'clock tomorrow. We'll be back with the news right after this.
Here with the Rainier Avenue Radio traffic update. You can listen to us in your car 24/7 anytime.